Good afternoon. Welcome. Thank you for coming. My name is Amy Corbin, and I am a staff attorney at the Children's Commission. I'd like to welcome you today for the webinar that's going to focus on representing older youth in care. The MCLE number for this course will be provided at the end of this live presentation. For those who will be watching on webcast replay, or if you need to leave early, please email the cctraining@txcourts.gov. Again, that's cctraining, one word, at txcourts.gov for the reporting information. This webcast is being recorded, and we will be putting this on our website along with the PowerPoint next week after this presentation. The Q&A feature is available for this webinar, and questions will be addressed at the end of the presentation if time allows. I am so pleased to introduce your speakers today, the Honorable Katrina Griffith. She's the Associate Judge of the Harris County Child Protection Court, and Sarah Worthington. She's with the Texas Foster Youth Justice Project. Today's webinar will feature a discussion of how to represent the unique interest of older youth in foster care. I'm very excited and will now turn it over to our co-presenters, Judge Griffith and Sarah, to start today's webinar. Thank you.
Thanks so much, Amy. Hi, everybody. My name is Sarah Worthington. I am the director of the Texas Foster Youth Justice Project at Texas Rio Grande Legal Aid, and I'm really happy to be here and talk with y'all about representing older youth in care and a lot of the issues that we see. A brief overview of what we're going to talk about. We'll do a very quick review of the ethical duties of attorneys representing children and youth in care. We're also going to discuss identification documents, why they're important, some of the challenges, and also how to make sure that your child's workers are doing their job and making sure they get their documents. We'll also talk about housing opportunities and education opportunities, benefits for youth both before and after they age out of care. We're also going to address some issues around criminal and juvenile involvement and disabilities. And hopefully, if we have time, have a discussion including questions and other issues. Hopefully this is a review for everybody. These are things that you already know. But all children in the temporary or permanent managing conservatorship of the state are appointed an attorney and a guardian ad litem. The obligation of the attorney is to represent and follow the child's expressed objectives of the representation, not to represent what they think is best for the child. That job goes to the guardian ad litem, but to represent what the child wants and what the child's goals are, even if you don't think they're good, even if you don't agree, even if you think they might be really bad choices. Your obligation as their attorney is to represent the child's expressed objectives. And because we may often disagree with our child's objectives and desires, it's important to be aware of dual role appointments when you are appointed as both the guardian and the attorney ad litem, especially when representing older youth, because conflicts between the child's expressed objectives and the best interest of the child are likely to come up as the child gets older. Thankfully, there is an option for an attorney appointed to that dual role to ask the court to appoint another person to serve as the guardian ad litem for the child if a conflict arises. If the court grants the attorney's request, then the attorney can only be the attorney ad litem, which means that your duty, again, is to represent your child client's expressed objectives. And it's your ethical duty to advocate for what your child wants. I wanted to check in with Judge Griffith on these slides, if this is something that you see in your court, whether you do many dual role appointments, or whether you grant requests very often to appoint a separate guardian if a conflict arises.
So I will, if a conflict arises, I will grant a guardian for an attorney that has a conflict when it comes to representing older youth, or even when it comes to representing the younger youth, because I do feel it's very important for the attorney to represent the child's express objectives. Even if the attorney is, wholeheartedly believes that what the child is requesting is not in their best interest, you also have to trust in the judicial system that the court can also recognize what is in the child's best interest. And that child needs a voice in court, and you are that child's voice in court. And to come and to advocate for them really allows that child to feel that they're being heard and that their wishes, even if it's not granted, is being taken into consideration. And sometimes if we just allow that to happen and they're there and they're part of the process and they know that somebody is on their side, that we can get them together to understand that maybe the decisions they're making are not in their best interest, and we can help them to come to a better solution. And in the end, also helping to understand that the attorney is going to represent them, and then the judge is going to be the one to make that ultimate decision. But it's really important for our other older youth to feel that they are heard when it comes to the court system.
Thank you, Judge. And we see that on our end too, when we work with a lot of older youth who have left care. Last year, we did a data collection project and asked youth with experience in foster care questions about their representation while they were in foster care. Half of them told us they didn't have an attorney, which we know is not true. But that shows what their experience was. They didn't think they had an attorney because they didn't have a relationship with their attorney. And of those, half that recognized they had an attorney said that their attorney actually advocated for what they wanted. Only half. So it's important to recognize that the experiences and the relationship and the trust with your child client in care has a lasting impact and really affects them later on when they either do or don't recognize that they had somebody in their corner while they were in care. We're going to dig into talking about identification documents. This shouldn't be new information for y'all, but all adults have to have correct and official identification in order to function, in order to apply for a job, in order to get housing, apply for public benefits, even get a library card. You have to have identification documents, and CPS is required under the law to provide those documents to youth by their 16th birthday, not at some point while they're 16, not at some point before they age out of care. By their 16th birthday, they're supposed to have all of these documents, their birth certificate, their ID, their social security card, and any original immigration documents if they are had a foreign birth. That means we need to get started a lot sooner than 16 to start getting these identification documents. And we'll talk about why, but at the front end, want to provide you with some resources. DFPS has created a couple of resource guides specific to obtaining personal documents and also driver's licenses and ID cards. These resource guides are, I think, in the later stages of being updated and combined into one guide. So keep your eyes out for an updated guide. But for now, these resources are available so you can see internally what DFPS recognizes as their internal processes and responsibilities to provide those documents to youth in care. There are a number of barriers to obtain identification documents. Some of these might include a birth that was never registered and requires applying for a delayed birth certificate. Those aren't super common, but they come up from time to time and can take quite a while to obtain the delayed birth certificate. Many times there's also incorrect names on birth certificates. We've seen a number of clients with an initial birth certificate indicating that their name is infant and that name needs to be corrected. Sometimes there are misspellings in names. Sometimes there's different variations of names that are used throughout the child's life. And so whatever is on their birth certificate doesn't match their social security card. The issue that we see the most often is a failure to update documents in an adopted name. Unfortunately, we know that the reality is that there are some children who are adopted that either return to care or are kicked out of their adoptive homes. And if those documents were not updated, these youth are left without any means to provide for themselves, any means to get these documents, especially if they were kicked out before they turn 18. In theory, the department should be responsible to update those documents if they haven't been updated and a child returns to care after an adoption. But unfortunately, we've seen very recent cases where that hasn't happened. So there are a lot of issues, a lot of problems that can come up, which makes it even more important to start that process early on making sure that those documents are, if not in the child's possession, at least in the possession of the caseworker or the placement before they turn 16. These problems are so much easier to address before they turn 18. If the youth is aware of the problem, they can talk to their attorney or their judge. They can call the ombudsman. We've provided the number for the ombudsman here in case it's not on your radar. That's a number that can only be used by youth under 18 in foster care. If you as an attorney have a problem, need to file a complaint, things aren't getting resolved any other way, then you can file that complaint with the Office of Consumer Affairs with the department.
So
I'm sorry, Judge Griffith, I want to ask you, what are some of these barriers that you see the most often, or barriers that aren't included on this slide?
So most often in court, I'm seeing that the kids don't have their social security cards, and that's taken a very long time to get. So what we do routinely in court is at 15, that's when I start asking the questions, do they have their social security card? Do they have the birth certificates? Because in order for them to have their ID before 16, that's the first two steps is birth certificate, social security card. So as an ad litem, those are questions that you need to be asking when you go and visit the child in the home, seeing if the caregiver has those documents, and it's the original documents, not copies of what we need to have. And when we're talking about the documents, we are always talking about originals. And the way the statute reads is that the child's supposed to have the original documents on or before their 16th birthday with them, so in their placement. And there are certain situations where it may be appropriate if you do have a youth that is a runner and likes to run, and that youth may agree, like, okay, yes, I would like my caseworker to keep those documents. And I think that is an important conversation to have with the youth, but it is the youth that is the one that's supposed to have those documents after 16. Another thing that I see commonly is I have youth that get their IDs, but then the caregiver doesn't let them hold on to their ID and they put it in a safe. And I tell them all the time that that's not appropriate. We have youth that have IDs for a reason, and that's to identify themselves. So if they're out and about and they get stopped or they get pulled over, they need the ability to identify themselves. I have very large kids in my courtroom, and when anybody sees them or officer sees them, they're not going to see them as a child. They look like grown men, and they need to be able to identify themselves. One of the common things they used to tell me is, well, I don't have a wallet. So now we start having wallets in the courtroom. So here's a wallet, put your ID in your wallet. And so it's also educating the caregivers that these are their documents and they are allowed to keep their ID on them. And yes, you may need to replace it, but that is also teaching them how to become a young adult. Is because when they lose at 18, if they don't know how to replace it, then we failed them in teaching them how to live their life after they leave care. So this is all processes and steps that we need to do. If you're not getting anywhere, any headway, you need to make sure you're bringing it up at your PMC hearings, at your permanency hearings, if they're still in TMC status, that they're not getting their documents, and make sure that the court's addressing that with CPS.
Thank you. This is kind of your how-to guide when you're trying to make sure that the department is doing their job in providing the birth certificate to your child client. For children who are born in the US, the caseworker is supposed to fill out this form 1745 and provide it to the foster care eligibility specialist, who orders the birth certificate and then sends it back to the caseworker. That's provided for in the CPS handbook. For children born outside the US, that gets a little trickier. For children who are born in Mexico, the DFPS border liaisons can assist with the request for a birth certificate. Otherwise, the caseworker needs to work with the DFPS immigration specialist for assistance. That's also outlined in the handbook. Now, I will note that for regions that have already entered the case management phase of community-based care, those processes might be a little bit different. The CPS handbook does not apply to the single source continuum contractors that provide community-based care. And so for those of y'all that are already in those regions, it's important to make sure you have your SSCC handbook and that you ask the questions early and often about their procedures and their processes for identification documents, and get copies of those processes so that you can hold the caseworkers accountable for making sure that those deadlines are met. The Social Security card is supposed to be the caseworker fills out the form for the Social Security card. It's not a special form for being in care. It's the normal Social Security card application. And they work with their regional SSI coordinator and possibly other regional staff to process that request. It's important to note too that the name on the Social Security card needs to match the name on the birth certificate. It seems very like, well, of course they would match, but you would be maybe would or would not be surprised at how many documents are not just, some may just have a first name and a last name instead of first, middle, and last. Sometimes they have different last names on those documents. And so it is absolutely critical that those documents match exactly, and that you double and triple check that those documents match, both, especially before the youth age is out of care. It's also important to note that Social Security Administration only allows 3 replacement cards in a year and 10 replacement cards in a lifetime. So that's part of what Judge Griffith was saying, part of training our clients and part of training these young people is making sure they know the limitations. If they lose it, if they have already gotten 3 replacements in a year, then they're just going to be out of luck, because there's nothing that anyone can do to max out or to exceed that maximum that the Social Security Administration has set. With getting a Texas ID or driver's license, the caseworker is responsible to complete a specific form that you will not find on their website, but it is linked here in the slides, Form 2042. It is a specific form for waiving fees for a driver's license or an ID or a birth certificate. There's a recent-ish state law that doesn't allow DPS or vital statistics to charge youth who are in foster care or extended foster care. It doesn't charge them the fee for their birth certificate or their ID or driver's license, but they do have to have this form filled out. Once the form is filled out, then anybody can go with that youth to get their ID. It could be the caseworker or a caregiver or any other supportive adult, but we do recommend that a supportive adult go with the youth to DPS. But you also have to make sure that other requirements set out by DPS are met. They'll need to take their birth certificate, their social security card, this residency verification. There's some fact sheets that we've also linked here for ID cards and driver's licenses specific to foster youth and what they need to bring with them. The Texas Foster Youth Justice Project has also put together some very detailed steps that take you through the process of requesting the birth certificate and the ID or driver's license for youth in care or in extended foster care. Some options and resources for attorneys is to follow Judge Griffith's advice and make sure that DFPS staff are requesting and obtaining the birth certificate and social by their 15th birthday, not their 16th, so that there's enough time to make sure that those barriers are overcome, that problems are worked out, so that they can actually get the ID card by their 16th birthday. And it's important to keep in mind that depending on where in the state you live, DPS sometimes has very long wait times to schedule an appointment before you can even go in to get the ID card. So can't, wait until a week before the 16th birthday and say, oh yeah, we'll just go over to DPS. They require appointments now. And again, they may be set out a month or two. So it's important to make sure that that process is started very early. We also recommend that the documents are brought with them to hearings, one, to show the judge that those documents exist and are in their possession, but also to make sure that copies are in the court's file, are in your file, or in the CPS file. It's much harder to replace documents if you don't already have a copy of them. We have a lot of clients who come to us asking to replace their birth certificate, but they don't know the information on their birth record. They may not know, their biological mother's maiden name to include on the birth certificate application. We often request CPS records to get copies, but there are plenty of cases where a copy of the birth certificate is not in the file. And then we really have a hard time getting creative to figure out how to obtain that birth certificate. And I'll ask Judge Griffith too to talk about what she's experienced with ID days with PAL.
So a few years ago, Judge Griffin, who is the judge over the Gulf Coast Permanency Court, got with the PAL down here and created what we call ID Day, which is a day with the local DPS office where just a group of kids that are ready for their ID will come together on one day. All the kids are pre-screened and all the documents are sent to the DPS office ahead of time. So we know when they walk into the office, they are going to walk out with their ID. It takes the stress of that day away. We know exactly what day it's going to be, so the caseworker can prepare, and everybody is excited. It's just a big fun day for the kids to go. They usually have 10, 15 plus kids. I'm trying to remember the largest one that they've had. So what I would suggest, if you're not already having this in your region, we've had several ID days now. They're trying to make it in region 6, more of a quarterly event, is to get with your local PAL program and see if they can start coordinating with their DPS office to create an ID day. It is easier on the DPS office if they know and they set aside one DPS worker that day that is going to just assist all of the kids that are in care, and everything is set aside, ready to go. They walk out, they have their temporary IDs, and it comes in the mail about 6 weeks later. It's very efficient. It's a very quick process, and the kids appreciate it. The caregivers appreciate it because they're not having to go back and forth, 2, 3 times because they're missing documents. And it's just a smoother process for the kids. One other note that I know we have come up on identifications, we have some kids that are in the process of getting their learner's permit, and they're like, well, I just want to wait and wait for my learner's permit. They still need to get the ID. So if they're not going to have their learner's permit and everything ready to go to be able to get that done on their 16th birthday, have them get their ID, and then they can switch it over to their learner's permit when they have those documents completed. So we're not just waiting for a delay because something could happen, placement could change, they could not finish, and then we're looking at 17 and they still don't have these documents.
And then we had a couple other follow-up questions, Judge, about what role you see attorneys have related to identification documents.
So the Texas Family Code does say that the attorneys also have a role in obtaining the documents. It's not very specific on how. They don't have the authority to actually go request it, but they are supposed to be inquiring about the youth and their documents. So if there are circle supports, when you're meeting with the children, you're meeting with the caregivers, make sure you're continuing to inquire, and every single hearing, make sure those are questions that you're asking in regards to your teenagers. And it's not just one time. So it's not just, okay, they got their ID when we came to our hearing in January, but when we come back to our hearing in April, do you still have your ID? Do you still have your birth certificate? Do you still have your social security card? And make sure that it's not been lost. And if it has been lost, making sure that it's been replaced.
And other than just asking questions, is there anything else an attorney can do to help youth make sure that they are being provided these documents by the department?
Well, I think they can file motions. Attorneys don't necessarily have the legal authority to go get the document themselves, unless the youth is over 18. And that's some stuff that probably need to work on more on the statutory side, but that's about, they can file motions. We can keep CPS coming to court. I've ordered caseworkers to walk across the street to the civil building and come back to court when they have the document in their hand. And the judge only knows they don't have the documents if it's brought to the judge's attention.
Great. And then I guess similarly, this might just be a different side of the same question. What can attorneys do if youth are not provided their documents?
And so from the judicial's perspective is you have to get in front of the court. And some of these things are often time sensitive, especially if we're at a point where the youth is getting ready to age out. If the youth came into care a little bit later, and so it's really getting in front of the court as soon as possible to make sure that that process is starting. If you know that there is a barrier, it's an out-of-state birth certificate. Sometimes the caseworker's waiting on payment for the birth certificate, and there's just unnecessary barriers. Get in front of the court and see if we can come up with some creative solutions to be able to get the youth the document as fast as possible.
Thank you. We're going to pivot over to talking about housing and education opportunities. There are quite a few and kind of growing housing opportunities for youth after they turn 18. The first that we'll talk about is supervised independent living. The supervised is in quotes because it's really not supervised. Supervised independent living is a type of placement in extended foster care where young adults live independently while continuing to receive support from the department, from their caseworker, and also from whatever contracted provider is providing the placement. Supervised independent living settings can include college dorms at participating college campuses, non-college dorms, houses, apartments. I've had clients just live in an apartment on their own, and you wouldn't ever know they were in foster care except they got a visit once a month from their caseworker. All of their living expenses are paid. Their rent is paid. They have a stipend for their living expenses. It's really the best possible option, in my opinion, because they have everything paid. They can really focus on working, saving, going to school, and really getting everything built up to the point that when they do eventually exit extended care, they're okay. They have to apply through their caseworker, but you can also contact the state SIL lead, Alina Jones. She actually did a presentation with our staff last week, and it was super helpful to hear more about their process and how they are working really hard to overcome a lot of the barriers that we'll talk about on the next slide that a lot of young people experience when trying to access this benefit. Section 811 is a rental assistance program that's administered through the Texas Department of Housing and now I'm forgetting TDHCA, Community Affairs, I think, for young adults with disabilities who are receiving SSI. It has to be young adults who have aged out of care, and they do have to receive SSI. Their disability has to be verified by a healthcare provider or a counselor, and you have to apply through a housing liaison with the department. But this is for a young adult who's able to live independently. This is an amazing option because it's long-term. Section 811, as long as they continue to be eligible, they can continue in that placement until they're, I want it either 62 or 65. It is a very long-term benefit that they can be eligible for, and really, really ideal for someone who is surviving on an SSI check. There are also kind of a new housing voucher programs, FYI and FUP. FYI stands for Foster Youth to Independence, and FUP stands for Family Unification Project. Those housing vouchers are available to young people who have had any experience in foster care. This is another pretty broad benefit. We recently learned that it's not just for youth who have aged out, it's for any young adult who was in conservatorship as briefly as 1 day. So this is available for youth who were people who were adopted, people who were returned home, people who exited care with a permanency care agreement, any of those, as long as they were in conservatorship for a day, they can qualify for one of these housing vouchers. And they're available age 18 to 24 up to 36 months, as long as they remain eligible. Some of the barriers that we're going to talk about on the next slide also apply here. Just a couple of examples. They have to, have all of their ID documents in order to go through the housing authority process. They have to, be able to pass a background check that the apartment provider may have. So there are still some barriers, but these options can really, really be life-changing for youth who don't have any other support when they leave care. Some of these barriers are really hard to overcome. Extended foster care is not going to be available if a placement cannot be found. And something that we have seen is a lot of misinformation being shared by caseworkers who will tell their youth that they cannot apply for extended foster care because they're not going to have a placement. Just making that determination on the front end by saying, well, you just got out of the psych hospital, so nobody's going to take you, or you have this criminal conviction, so nobody's going to take you, and making that decision on the front end when, again, our training with Alina Jones from the state office, she dispelled that for us very quickly. And I'm thankful for that, because she said the caseworkers, that it's not their job to approve or deny an SIL application. Their job is to submit the application if their youth wants them to. And she has the responsibility to approve or deny. And she is making every effort to approve those applications, working with contractors to accept even hard to place young people. And so you may encounter that with your cases and with your youth, that they may be, one of those that's in that, really complicated and troubling cycle of being in CWAP and then going to an RTC and ending up back in the hospital and then back to CWAP. They may have some juvenile or criminal history. They may, have had some problematic behaviors while in care. Those things should not exclude them from stable and safe housing. And so it is, from what we've seen and understood from the department, their mission is really to make sure that youth who are aging out of care have safe and stable housing through some of these options. So part of the barrier is overcoming the misinformation and misunderstanding of what the rules are. But the folks at the state office have been so helpful, Alina especially, and Jim Courier, who's their housing specialist, in identifying opportunities for especially hard to place youth. For Section 811 and the voucher programs, they tend to have long waiting lists, especially in more urban areas of the state. There are also transitional living centers. Feedback I've heard from clients is that they don't usually feel safe. They have things stolen. They've experienced assault. So those, depending probably on like the level of supervision and whether they're licensed or not, this can be a toss up. But the reality is that many youth who exit care do end up in shelters or homeless or in unsafe living conditions. So there are a lot of barriers to accessing the opportunities that are available. Judge, have you seen some housing plans for youth who have not been accepted into SIL or extended foster care, and kind of talk about what you've seen and what happens with them?
So, and when we're talking about the youth that aren't accepted, what I'm seeing, those are our youth that are usually already in some kind of fictive kin or relative type placement. It's rare now. I will say this is one thing I can say about CPS from when I started this job 10 years ago to now, that if they're already in a foster home or a paid placement, I'm seeing it less happen that they're not able to find some kind of paid placement after 18 for them. That percentage is really coming down on my caseload for the kids. But when that does happen, we are looking at the Covington house, which is through the Hay Center. And we are looking at more of your transitional living centers that we have here as the options for the more non-traditional. But to try to start preventing that on the front end, ad litem's really need to start talking at 17. What is your 18 plan? Are we doing extended care? Start looking at it and start communicating with the youth for at least a year in advance about what that's going to look like. Because we know oftentimes our kids do not graduate high school when they turn 18, not just our kids, all kids. Mm-hmm. They're still in high school at 18. So what is that next step going to look like, and start that process, so then we can start reducing the number of kids that turn 18 and then they don't have a plan to be able to get into an SIL or the Section 811, because that application can start at 17. Like, we can start, if we know that that's what's going to be the plan after 18, we can start those applications at 17. So hopefully by the time that it's time for that transition to happen, that we have some more options coming up. But when it does happen, we are looking at, like you said, we're looking at the different shelters. They're looking at a lot of couch surfing, which is also why we say, hey, if this is what your plan is, if you don't want to apply for the SIL program, you don't want to do the extended care, then that's fine. Let's set another hearing in a few months after you turn 18. Let's come back and see where you are. And we also talk to them about letting them know that the options are still open and you can come back, and we can come back and see, in 3-4 months, if you want to come back and re-enter into care and do your SIL application. And we have a lot of youth that come back and say, well, that really wasn't what I thought it was going to be. And I think I do want to try this other options. And so making sure that they have the knowledge to know that even if you do decide to leave, that's fine. But we're still here and we can still help you on the back end.
We're also going to talk about some education opportunities. Hopefully, these are things y'all already know, but we have a tuition waiver program in Texas. Youth who qualify because of their role or their status as a foster youth, they have to enroll in at least one class before they turn 25. They don't have to finish the class. They don't have to get a certain grade in the class. Sometimes we hear feedback that, again, youth are being given some misinformation, that they have to meet certain criteria that simply doesn't exist. So to lock in the tuition waiver for life, they just have to enroll in one class before they turn 25. There's no age limit for adopted children. For some reason, there's an age limit for foster youth. And the waiver is only accepted at state-supported colleges. So they can't go to a private school and expect the private school to accept the tuition waiver. It's only at state-supported colleges. But just like there's no age limit for the adopted children, there's no age limit on when they can use the tuition waiver. As long as they lock that benefit in before they're 25, they can continue taking classes as long as they're alive, as long as institutions are accepting applications and they can enroll, then their tuition and fees will be paid. And they can get a bachelor's, a master's, a PhD, they can go to law school or medical school. As long as the program is at a state-supported college in Texas, there's no limit to what they can do with their education. The education and training voucher is a financial benefit that provides up to $5,000 a year for education related expenses. But one kind of caveat there is that the funds that are available cannot exceed the cost of attendance, which is a number that each institution comes up with on their own. And it can't exceed the cost of attendance after other financial aid is applied. So if someone is receiving grants and scholarships and that meets the cost of attendance, then they won't be eligible for any ETV funds. This is something we've learned about kind of just recently as we've had some younger clients apply for ETV and be denied and digging into it. So that's an issue that you may have some young people encounter. There are foster care liaisons at every college that accepts the tuition waiver. We've provided a link with contact information for all of those liaisons and some advice that we give to our clients when they're trying to decide where to go to college and look into where they might have the most support is to contact the foster care liaisons at the colleges they're interested in and find out, do you have any supportive programming for foster care alumni? What kind of support does this school offer? And you may get somebody who says, oh yeah, I'm the foster care liaison. I don't know. And they don't know, they have that designation, but it's not something that they're invested in. But then there's other colleges that have fully staffed programs specific to serve this population. So that may play a part in how they choose where to attend school. We talked about supervised independent living. The supervised independent living placement, some of them are at college campuses, which can just make the entire experience so much better if they don't have to worry about their room and board, they don't have to worry about their tuition, they can really just focus on school and their studies. We've also provided a link to all of the contracted SIL providers. Texas Workforce Commission has some programming that's usually delivered through the transition centers, but they also offer vocational rehabilitation services that are available by referral. Laura Villarreal is our contact at Texas Workforce Commission for those referrals, so you can email those directly to her. Judge, do you have any thoughts about what questions attorneys should be asking to help youth access these housing and educational opportunities?
So the first question is asking them, like, what is their plan? Because we can create a plan for them, but if it's not their plan, it's not going to be helpful. So I always ask them, like, what is your plan after high school? Excuse me. And that, well, before we ask about what the plan is for high school, it's what is your plan to graduate? So if they're going to be graduating high school after the age of 18, it's what is that housing going to look like in that time before they graduate high school? So are we going to go into a SIL? Are we going to stay in extended foster care in your foster home? Like, what is that going to look like? Because the success for graduating high school is often higher if they remain in that foster home type placement than it is going off to a SIL. And I do want to say this about a SIL. It is called a supervised independent living center, but if you've ever visited one, there's no supervision. There's no adult living in the home with them. There's an adult that may check on them. There is a case manager and there's a contact person for them, but they are on their own. They're on their own to get up in the morning. They're on their own to go to bed. They're on their own to do school, and they're on their own to get to school. Excuse me, they're on their own to do their homework, and they're on their own to get to school. So they really have to be ready to finish out their senior year or whatever year they're in, if that's the plan that they go to. So first, that is our first starting point. And then once we get out of high school, we have our diploma, then we're talking about what's the next step. I do encourage the kids that if you're going to go to college, let's do a college with a SIL program, because that takes off a huge burden of college. The biggest financial burden for our kids, because they don't have tuition, is the housing. But there's some things that go with that too. We do have some kids that graduate at 17. I've dealt with this 3 times now, and they start college at 17. Well, they're not eligible for the SIL program. So we do have to figure out how they're going to pay for the housing for a little bit. And then we have kids that are going to, well, all of our kids will be in college after the age of 21 if they're going for a 4-year degree. And what happens when they turn 21 in the middle of the semester, because SIL cuts off, and then they have a big bill for the rest of that semester. So we always have to be very mindful of that and knowing which route that they want to go. college is not for everybody, and we may be talking about trade schools. And we also realize that that tuition waiver doesn't apply to trade schools. Not all trade schools, but there are some, like the technical colleges, that it does go to. And if they can't get the tuition waiver, they may be able to use their ETV at the trade school. So we're just making sure that we're following what path and plan that they have. And you can only do that by starting to ask them, like, what is your future plan and what do you see and what steps can we do to help you obtain that goal?
Awesome. And have you seen attorneys creatively addressing some of those barriers that we talked about to the housing opportunities?
I mean, typically, I guess the most creative thing is they just come in asking for court orders. That's what we deal with. As far as creatively addressing housing opportunities, there was a push by attorneys for starting to visit some of these like SIL programs and for the kids to start seeing them earlier. And I know Elena has started that program up where they're doing SIL tours that has started around around the state. And also, you know, reaching out to family members and trying to build that gap to make sure that there's not housing instability. Attorneys, you know, finding community people, or, you know, hey, there's this coach that's really interested in the child, or, you know, we recently had one where it was the young man had a teammate on his football team that was interested, the family was. And the attorneys brought that to court, and, you know, we started making that push. And, you know, there's plenty of opportunities for stability in housing and long-term and placement for our kids. And we got to really just not think of the traditional foster type placements. And we got to start thinking outwards and into the community to start to find opportunities for our kids.
So next we're going to talk about benefits. We have one slide for benefits under 18 and the rest will be for over 18. Obviously Medicaid is provided for youth in care through Superior. They cover services and medications. Telehealth options are also available, which can be especially helpful for youth who have had a lot of placement changes and may have the option to have some kind of continuity with their healthcare provider or counselor. Superior also offers transportation to non-emergency medical appointments. So you may have a client whose foster family is really struggling with getting them to certain appointments that they need. So an option might be to loop in Superior to help with some of those transportation needs. PAL, the Preparation for Adult Living program, is available. They provide life skills classes. You'll hear your clients talk about going to their PAL class. If they complete that PAL class, it allows them to ask for their transitional living allowance, which we'll talk about on the next slide. Or in 2 slides, that they can access when they leave care and are living independently. PAL also provides aging out seminars, college tours, camps. So they're really focused on that transition and remain available after youth turn 18, and are sometimes the only person left from the department that they maintain contact with after they leave care. The PAL staff are also usually the link to a lot of these benefits that we're talking about. Now, very, very soon, a free driver education program will be available to youth in care and out of care, as long as they're, I believe, under age 26. That program will be administered by the Texas Workforce Commission. The laws creating this program were implemented in 2021. There were some kinks that had to be worked out in 2023. Workforce Commission has already hired a program coordinator. They're working on final language for the forms. I believe there's already driver's education schools that are contracted with the state to offer the driver's education. So this is going to be a really big deal, especially because in the past and present, PAL has taken on a large burden of paying for driver's education programs. And so now with the built-in funding from the state, this is going to free up PAL funds to do other things, and it's going to offer a more sustainable program for youth in care and who have left care to make sure that they are able to get their driver's license. The driver's education program doesn't just cover classes, it covers all costs associated with getting their driver's license, including taking the test and all those other pieces of that process.
Sarah, before we go on,
yes.
I want to circle back to transportation real fast
Yes.
for the non-emergency medical appointments, and just point out, so we're talking about older youth, and one thing I do hear from the older youth is about their therapy, and having to do therapy, you know, in the home, because sometimes that'd be a barrier, them not wanting to talk. So one thing about this transportation service at Superior does office, if you have a youth that doesn't want to do that therapy in the home, they want more of a private session or work with a different therapist than the CPAs is requiring them to do inside the home, or because that's what's convenient for that home and that caregiver. If you're able to, as an attorney, work with the youth to locate a therapist that's provided by Superior, that they can go to the therapist's office, that the youth may feel more comfortable, and transportation is a barrier, this is a service that can provide that transportation. Maybe the youth gets picked up from school and then returns back to the foster home afterwards. And then we can eliminate that. Well, the caregiver is like, well, I don't have time to transport him to this appointment and that appointment. So we can start providing more services that are tailored to the youth, as opposed to just what's convenient for the household.
That's a great point. For benefits for young adults, we've talked a little bit, some of this is duplicative, but just to keep them in the right sections. We've talked about extended care and supervised independent living. To be eligible to remain in extended care, you do have to have been in conservatorship on their 18th birthday, and they do have to sign an extended foster care agreement. This is another area of some miscommunication. There are some caseworkers who tell youth that they have to sign that extended foster care agreement before they exit care, and that's not true. They just have to sign that agreement before they enter an extended foster care placement. So if they leave care at 18, they come back at 19. As long as they sign that agreement before they enter the placement, they can still enter the placement. They don't have to sign it before they leave care. And again, extended foster care and SIL, they're limited to placements that are available and will accept that young person into their program. If someone has left care and want to come back, they can contact a DFPS reentry liaison to start that process. And youth or young adults can remain in extended foster care until they turn 21, or if they're still finishing high school or in a GED program, they can stay in care until the last day of the month of their 22nd birthday. This has been especially helpful for young adults with disabilities who are either like taking time to get their diploma, need more time, or just staying in special education services as long as they're eligible for them. There's also transition and financial support services, which involve ongoing case management from a local service provider. That link takes you directly to all the providers for each region, and they help identify options for housing, employment, education, and they can be a conduit to apply for benefits as well. And they can receive those services until they turn 21. A transitional living allowance we touched on with the PAL class. If they complete their PAL class and they're living independently, they can request up to $1,000 in 2 chunks of $500 in 2 different months. They have to be working or going to school to qualify, or going to like a job training program, or have a disability that keeps them from performing any of those tasks. But there is also like a few other like footnote type eligibility criteria that could possibly exclude young adults from receiving the benefit. So there's, I would advise you to visit that section of the CPS handbook to learn more about the transitional living allowance, especially if you hear from a client that they've been told they can't receive it, because there's some smaller things that can prohibit them from receiving that benefit. Aftercare room and board is another financial benefit that's not paid to the young adult, it's paid to the person that needs to be paid. So the qualifying criteria is if the young adult has a need for emergency or stabilizing assistance, which thankfully the department reads pretty broadly. They can request up to $3,000 in total, not to exceed $500 a month to pay expenses like rent or bills or buy groceries. The department will write a check directly to the landlord or to the electricity company or water company, or provide gift cards for the grocery store. So that's another benefit that can help, especially when a youth gets behind on rent, is looking at having their lights shut off. Those things kind of help them stabilize and hopefully move forward and get stable. And that's another benefit that they can receive until they're 21. Both TLA and the aftercare room and board, they can request from their PAL worker. The aftercare room and board, they can also request from their transition services provider. We've talked about the tuition and fee waiver and the education training voucher already, but the only thing that I'll add is that the tuition waiver is requested from PAL. We get more calls to our hotline with questions about the tuition waiver than anything else by far. And it's a lot of young people, it's a lot of supportive adults, but we also get calls from CPS asking us for the tuition waiver when it is their own agency that provides them. So there is a lot of misinformation, a lot of confusion about where the fee waiver forms come from, and they come from PAL. They should be able to ask their PAL worker. If they can't reach the worker, they can reach their PAL coordinator for the region. If they can't reach their PAL coordinator for the region, they can contact the state office. And we are very happy to help connect young people with the appropriate people to get with the appropriate PAL staff to get their tuition waiver. The education training voucher, we also talked about, I don't remember if we talked about amounts, but it's $5,000 a year as long as it doesn't exceed the cost of attendance, and they can receive that benefit until they turn 23. Applications for ATV go through a contracted provider called BCFS, and there's a link, when y'all get copies of the slides, you'll be able to click on that link to get to the ATV application site. Medicaid benefits are huge for anyone, but especially for this population. Youth who age out of care generally are eligible for former foster care child Medicaid, or FFCC. But technically, there are a couple of criteria. They have to be in conservatorship when they turn 18 and receive Medicaid when they turn 18. And the only reason that that distinction is important is because when youth are incarcerated, either in a juvenile or an adult facility, their Medicaid benefits are cut off. Carceral institutions are responsible for providing health care to their residents. And so when DFPS finds out that a child in their care has been incarcerated, they end their Medicaid benefits the same day. And this is important for youth who are nearing their 18th birthday, because this arbitrary rule of receiving Medicaid on this one point in time, their 18th birthday, can restrict them from receiving FFCC, which if they're receiving FFCC Medicaid, they can receive those benefits until they're 26. If they are not receiving Medicaid when they turn 18. So if they're in jail or in some other carceral institution, when they turn 18, that benefit is not available to them anymore. There's kind of a backup. This MTFCY, Medicaid for Transitioning Foster Care Youth, can be available for young adults who don't qualify for FFCC. They still have to be in conservatorship when they turn 18, but they don't have to be receiving Medicaid. But that coverage is only until age 21. And so as you can see, this is a really, really big deal for youth who may be in jail when they turn 18. They could be losing out on 5 years of medical coverage. It doesn't, like, the disposition doesn't matter, whether the arrest was right or wrong doesn't matter. It only matters whether they were receiving Medicaid. So that's important to keep in mind if you are working with older youth who are nearing 18, especially if they are in a placement that puts them at a higher risk for arrest. So please keep that in mind for your clients who are getting close to 18. A few other tidbits about Medicaid. Non-citizen young adults lose FFC benefits by their 21st birthday. So if they are eligible to naturalize, like anytime before they're 21, it's good to encourage them to do so as quickly as possible so they don't lose their Medicaid benefits. Most youth transition to FFCC at age 18 automatically, but it's good to double check because sometimes things fall through the cracks. All youth or all young adults, either on FFCC or NTFCY, still have to renew their coverage annually. The only criteria they still have to meet is residency in Texas. So they just have to affirm that they continue to live in Texas to continue to be eligible for that benefit. There's also Superior has a My Health Pays program that provides financial incentives up to $125 a year for completing different activities like going to checkups and getting flu shots and that kind of thing. So I know we're getting close to time and we still have some more things, but Judge, what role do you see attorneys playing after a youth turns 18?
So really it is to support them if they're needing any documents, if they're needing assistance getting onto the Medicaid, assistance getting with the caseworker, if they're still in a extended care, making sure that they know about their court hearings and bringing them in. If they're in trial independence, letting them know that they can still come to court. I keep my attorneys on during the trial independence period, so the attorneys can still engage and reach out to the youth, and they are still by statute allowed to help them and assist them in any way that they can with transitioning to adulthood, which is, how the statute reads.
And how can attorneys best support youth to make sure that they're aware of their benefits and can actually access them?
So I think the best way, first of all, is coming to something like this so the attorneys are aware, because a lot of times the attorneys are not even aware of what benefits are available to them, giving the information to them. So we also have to remember, youth, they hear things once, they're going to forget. Like, it has to just continue to come at them. So they're hearing it from the caseworker, hearing it from the PAL worker, hearing it from attorneys, hearing it from their judges. When the more the youth hears it, the more likely it is to sink in. So everybody needs to be on the same page and making sure that we're continuing to talk to them about their benefits. If you see a need that you don't know, whether or not the youth is eligible for something, reach out to the PAL worker, reach out to the caseworker, come into court and see and figure out if there's some services that can help the youth if they're still in trial independence, or even if they're out of trial independence and they want to sign to stay in to do extended jurisdiction till 21, and they're accessing transitional services. The court can still be in assistance to that youth until young adult until they're 21.
And do you see, this is like related to this third question, but what does it look like in your court to continue to hold DFPS accountable after the youth turns 18, either in extended care or after they've left care altogether?
So we will do extended jurisdictions hearings, service review hearings, trial independence hearings, have the youth come in, check on them. If the youth needs anything, as long as the court has jurisdictions, and if we need to do a court order to get DFPS to do something that they are required to do, the court will do that within the bounds of what the law is. And that's how we will hold them accountable. But sometimes it's just coming together and having a conversation and getting on a page of what the young adult actually needs, and really figuring out what the young adult needs and being able to work it out from there.
So we'll go through these. I'm sorry that we have to go so quickly since we're about out of time, but it's important to be aware of the consequences of juvenile and criminal involvement, especially we talked about the effect on Medicaid, and recognize that youth who are in care are at a heightened risk of arrest, especially if they're in CWAP or a residential treatment center or other congregate care facility. There are some certain remedies available for youth who are charged with Class C misdemeanors if they're under 17. There's also some opportunities for youth if they're in care or extended foster care, even if they're 17 or older, to avoid fines. And details are there on that side, and links will be available to you. It's also important to be aware and that your client knows what their options are to seal juvenile records, to potentially expunge criminal records, especially if they completed pretrial diversion, and to look into whether an order of non-disclosure might be available if an expunction is not. Our office does these cases all the time because of the fact that these create such massive barriers to housing and employment. So in the juvenile system, they're supposed to give them information about sealing, but that doesn't always happen. So it's important to just educate yourself and be aware of all the options to limit barriers to your clients being independent after they leave care. And I also want to point out the importance of looking into whether your client is a designated or an alleged perpetrator in a CPS investigation. If your client's accused of perpetrating abuse on another child, they will be on the central registry for the rest of their life. They fall under this 99-year retention policy because they were subject to a removal themselves. And so any kind of accusations made against them are merged in their file, and they will remain on that central registry if there's a reason to believe finding against them. And so that can impact their ability to work in childcare. It can impact their ability to become a foster or adoptive parent themselves. So it's important to know the options that are available to advocate for your child or youth client in those situations. You can request an administrative review of administrative findings. the typical deadlines do not apply if the investigation or the disposition happened when the person was a minor. And then those an unfavorable ARF decision can be appealed to the State Office of Administrative Hearings. Judge, do you have thoughts on either the responsibilities or limitations that attorneys have when youth have juvenile or criminal involvement?
So, I mean, there definitely are some limitations because these are appointments and the appointments are for the CPS case. But I think also if you're truly representing your client, then you need to know what's happening in the juvenile case or on the criminal side without crossing over to the representation side. But there are some judges that I have spoken with that are okay with the attorney being, involved as long as they're, not appointed on both sides and billing on both sides. So it's really knowing your jurisdiction and your judge and your jurisdiction on how much involvement you can have with assisting them on the juvenile side. But oftentimes, going to the juvenile hearing and that judge knowing, okay, they're in CPS care and these are some other options that might be available if I'm not going to, put them into a juvenile placement or letting them know the different options can be very helpful. And that can happen with the CPS attorney there, especially if it's a jurisdiction that doesn't have a good dual status program yet.
Thank you. And then I know Amy, you'll have to let me know when we have to stop, but there are also some options for youth with disabilities that are important to know related to home and community-based services and the timelines and tasks that have to happen in order for a youth or young adult to access that service. There's a lot of really important information about guardianship and how that should only be a very last resort. Alternatives that are available when guardianship is not appropriate. Some issues around extended jurisdiction that are important to be aware of, and then issues around SSI. I'm so sorry we had to rush through those. And I don't know if you have time for Judge Griffith to respond to issues around youth with disabilities, but
I know we are at a time, but our youth with disabilities are very, very important because there are deadlines as well, and making sure that they're getting their DIDs done before they're 18, and making sure that the applications are in and done properly for the dads. And really, as an attorney representing a youth with a disability, you need to make sure that you're aware of how those systems work as well, so they're getting the right services and not being put in the dad system when they don't have to, or making sure that when they really need to get into that system, that everything's in place for them to be able to transition so they have success in their adult life as well.
Thank you both. Sarah, if you'll go, there it is. We know that there is a ton of questions that we were unfortunately not able to get to. You can reach out directly to CC Training or Sarah's organization info@texasfosteryouth.org. On behalf of the Children's Commission, I would like to thank Judge Griffith and Sarah for providing this excellent presentation. I know we could have easily gone another hour, and we are just so grateful for your knowledge and your sharing this today. Thank you for everyone who joined us for the live webcast. For those who are watching us on recording, you can please email the cctraining@txcourts.gov. Thank you.